Yes, we're looking at a topic that is gaining traction in Trinidad and Tobago, as it should, because we don't have much precedence at all for it, and it's medical negligence. All right, our guest is attorney at law Joseph Sookoo. He comes out of the Regius Chambers, that's Wayne Sturgis Chambers. Joseph graduated, he said. He was called to the bar in England in 2010, so you may think he's relatively young, but young and fresh, and is possibly... We have not checked all the records, but right now he is within range the only attorney who's dealing with medical negligence, who can and is qualified to deal with medical negligence issues in Trinidad and Tobago. He also deals with complex civil litigation, judicial reviews, and appeals. And he's been practicing in Trinidad for the last 4 years after he was called to the bar in England in 2010, studied at the University of Essex, where he specialized in medical negligence. One of a few persons, as we said before, who went into that area of training at the time, and possibly the only one in Trinidad and Tobago right now. And as he explained to us, Trinidad and Tobago is behind UK law by about 10 to 15 years. So he said, when I specialized in the university, I foresaw the need for it. It is also pretty recent in Britain. The first case in medical negligence in Britain was in 1986. And here in Trinidad, our landmark case was 2008. He will correct some of the things that I am saying here. He's already indicated that. Good morning, Mr. Sookoo.
Good morning, Ms. Baboolal. Well, medical negligence is one of the more stranger areas of law, insofar that it's really, in terms of the regular practitioner, a bit of magic. The fact remains that in order to prove a case in medical negligence, you really need to get expert evidence. In particular, you need to dive into what doctors are supposed to do and how they're supposed to do it. When I speak about landmark cases in England, medical negligence only really took off in the 70s, right? It really forwarded from, let's say, basic broken arm scenarios and all that, and further went into, and this is the main area these days, into medical negligence involving babies, children, and childbirth. In Trinidad and Tobago, we really picked up on that somewhere close in 1986 in a case called Grace Primer.
Oh, it is Trinidad and not Britain in 1986.
Correct.
Thank you.
Yes. And that's really set down a lot of the basic law that we follow. If I recall, in 2008, there was also a recent case as well. It went to the Court of Appeal. This matter, I believe, involved a child. Well,
was it Samde Harilal?
That's the one. Yeah? Yes, Samde Harilal. And that's actually a rather tragic case in the circumstances. But that really set down a lot of the law with respect to how we go forward in these sort of matters.
Good morning. It's good that we have you here. You can answer a whole lot of questions that we have for you this morning. The case, I think, was heightened. The situation of medical malpractice was heightened as a result of what took place at the Eric Williams complex just this week, where many folks are saying what they are looking at, which is a deep vein thrombosis being the early thing that caused the death, folks are saying, of Keisha Ayers. And this raises the question that if you go for a simple C-section, you expect certain things to happen at the hospital. You expect them to know certain things. You expect them not to discharge you if you're vomiting, if you're fainting. And a lot of folks are putting it forward that this is a case of medical negligence. So before we go deeper into the area of that, I know you sort of laid the bed for it, but what is the bar? Define, if you will, for us, what is medical negligence?
Right. Medical negligence is a situation where a doctor or medical facility has failed to meet that duty or that standard of care necessary for treating a patient. Now, you can pretty much term it in the regular word negligence, but for legal purposes, negligence must be followed by damages which can be attributed to the actual, and I'm using the word negligence here in the common sense, to the negligence of the doctors. So, for example, a doctor could be negligent in performing a certain task in the common way. He should have done it one way, but he did it in another. But if that actual action doesn't lead to the patient suffering a certain consequence, he's negligent on a very basic scale, but not negligent in a court of law.
But from what you're saying there must be something to compare it to. If he must perform his duty to a certain standard, speak of that standard. Who sets the standard? Do we have such a standard here?
Well, the standard is actually same worldwide. It's a reasonable body of medical opinion. Certain treatments required can be treated in different ways. If I was to use a very simple example, let's say you have a headache. There are two types of headache medication as far as I know. You have those based in caffeine and you have those based in paracetamol. You go by a doctor can offer you aspirin, which is paracetamol based. You go by a doctor, he can offer you something like Vasograin, which is caffeine based. They both do the job. But if you say that a doctor should have offered you aspirin versus Vasograin, you will find that, well, where's the damage there? Because any group of doctors would have done one or the other. It is when that doctor goes outside of what is accepted. So let's say in the same circumstance, he gives you morphine. That's really going too far. Most doctors would not do that, and you would not get a reasonable body of medical opinion saying treat a headache with morphine.
Is it medical negligence, for instance, for Sharmain or yours truly to go into a doctor and they start a process to correct whatever our ill is, but not pay sufficient attention to our medical record to see where complications may arise? That failure to do that, does it qualify as medical negligence?
On a very basic scale, yes. But you have to attach the failure to look at these records to what ultimately occurs.
I see, to the injury, as it were.
Yes.
All right, and should something like that happen to me, what is my space? How long can I, because sometimes you can do something and not show up for a couple of months or maybe a year. What is the limitation as to when I can take action? Should I be or believe I am the victim of negligence, medical negligence?
Right. Now, to say that to take action, there are actually 4 regimes you can actually take action in. The first is in contract. If you go to a private practitioner, for example, there's a contract between you and him for him to treat you properly. So you can sue him in contract. The limitation of that is 4 years. The second step, or another remedy for you, is to have him disciplined pursuant to the Medical Boards Act, which is where he failed to meet a standard that a regular doctor would and would be in breach of the act and his duty to patients generally. That would be sanctions, punishment for him. You have, I understand, about a year to make a complaint like that. Albeit, of course, I presume to extend it. That could include the doctor losing his license. You have a third regime, which includes the criminal regime, whereby if the action itself leads to like death or could be really grossly negligent in that regard, the doctor could be brought up on criminal charges. And the last one, which is really the civil regime, the medical malpractice regime, again, 4 years.
I know Sharmain is jumping at a bit. I just need one further clarification. In the area that you have mentioned there, we have looked at you getting into the legal end of it, but you must have an umbrella to protect patients who are going into a doctor, i.e., if they are going to ultimately seek redress for something that has wronged them, monetary compensation will be the issue. And I have wondered before, and you can clarify for me, is there a mandatory insurance that every doctor must have if they are practicing?
My understanding that they should have it, but some don't.
But so it is not mandatory that they should?
No, it's not mandatory. As far as I understand in this jurisdiction.
So God help me if, okay. I'm sorry.
God help you if you're with a poor doctor.
Yes, Sharmain.
It's called medical liability insurance, and we've been told from our research that private doctors are required to have medical liability insurance.
Indeed.
But at the RHAs, regional health authorities, doctors who work at the RHAs and with the government have no medical liability insurance. So it means that the taxpayers will be paying for the negligence of doctors. There are no personal consequences to doctors.
The institution is responsible for taking care of that. Okay.
Which leaves the public health system open to
heavy litigation, yes.
Heavy litigation, not necessarily, but a certain amount of, I'm sorry, doctors, if I fall under your care, eventually carelessness in some cases.
Yes.
It's what some medical practitioners say about others. I wanted to ask, because the cases that we've had so far in Trinidad mostly are basically poor people who go to these hospitals and they get, they're wronged, and some attorney sees, well, look, here's an opportunity where I can put forward a case, and they go ahead and they do a case. Most times it could be for free. The cost of legal fees, for example, would be at least about, I would say, $1,500 an hour. You can correct me, it can be more than that. And then there's a retainer that which most people who seek redress in medical negligence cannot afford to pay. How can we get over that, one? And then it's a small society, so that if you have a case that goes to court, the experts who are required to give evidence would come from within this medical community, right? So therefore, you would ask a brother to give evidence against a brother, and how efficient is that? So how really can we go forward with medical negligence cases, or are we just trudging along?
It's, I guess, a bit more complex than that. When you're looking at medical negligence in Tobago, well, dealing with the first question, the cost is highly prohibitive. There are a lot of attorneys out there who work by, let's say, billing afterwards or after the fact. A lot of people out there are familiar with this this no win no fee scenario, which is actually isn't legal under our jurisdiction. That being said, for a lot of people, that's the only option they have, because the legal fees are bad enough, but it's the expert fees which really make it horrendous. In my experience, realistically, to bring a medical negligence case to court for the larger claims, let's say for incidences of death and serious injury, you're looking at having not one, not two, but in most cases 3 or 4 experts having to come to court. I'm actually familiar with a matter that's before the courts right now, where I think 17 experts were necessary to deal with not only medical issues, but financial issues and long-term issues in terms of nursing care and these sort of things. The cost of that, I am informed, is actually ran the client into millions.
Joseph Sookoo is the voice you're hearing. He is an attorney, and he is giving us clarity and guiding us on this whole issue of medical negligence. We've been talking about doctors so far, but it is not only doctors who can in fact be sued for negligence. It's anybody in the profession, i.e. nurses and so on in a hospital. Is that, am I correct on that? Oh, by the way, I believe the limit for filing action in Trinidad, they say, is 4 years, I think.
Yes.
And so in the case of other practitioners, they can also be sued, i.e. registered nurses and those things.
Yes, any medical professional who provides services in a medical way will be liable in these sort of things.
So for the claimant, he gets cost. Can he demand cost if at the end of suing and having to pay all this prohibitive amount of money to get experts in, can he ask the court for cost?
Yes, he can ask the court for cost.
And the precedent is, the norm is what? That it is in fact awarded?
The norm actually, as far as I've seen it has hardly been awarded.
That's a disincentive for you to go to court on that. The types of claim, most folks think that you cannot fight City Hall, so they feel that the bar is so high to make a claim that it becomes zero return, and they don't do it. What is some of the claims that you hear, one, and how high is the bar to sue one for medical negligence?
Well, interestingly enough, you mentioned deep vein thrombosis. I actually specialize in those sort of cases. The difficulty with those cases that deep vein thrombosis, for example, carry, it's actually a very difficult area of medicine to really show the causation issue. Because you get a deep vein thrombosis, which is normally caused by laying in bed too long or lack of movement generally.
Clots.
Yeah, clots. These clots then break up in the leg or other extreme body parts, move into the chest, cause an embolism, you die. Normally, these are generally accepted risks of being in a hospital, because if you get a broken hip, for example, you're not going to be moving. You are at risk for getting a deep vein thrombosis. And with proper care, the statistics suggest that in 95% of the cases, that never ought to happen. But in the next 5%, even with proper care, you do get a deep vein thrombosis. It's then for you to try to minimize the risk of the ultimate embolism occurring. And again, the statistics suggest that you can do it. But to actually show that it could have been prevented before is sometimes a very difficult process.
But because it is so common, is it not incumbent on the practitioner to look in the case of this C-section? They say if you have natural birth, there is no blood, so there is a lesser chance of you developing the situation. If you have a C-section, then you are more disposed to have it. Cognizant of that, is it not incumbent on the medical practitioner to be more observant and do something? In the case of this lady that just happened last week, I mean, that is troubling to me because if you see a situation and you're the experts, you see a situation and you know what is likely to happen, then I would expect that due diligence would have assisted them in not having her go home to the extent and stay there until the problem developed where she could not even walk to get back to the hospital.
Yes, and I entirely agree with that. What you speak of is something called a high index of risk or high index of suspicion of risk, right? It's actually quite simple to explain. If you're in a circumstance where, if you look at all the factors, if it looks like a duck, it talks like a duck, it quacks like a duck, you pretty much should say, let's see if it's a duck before we go on.
Indeed.
In a thrombosis scenario, you know what are the risk factors. The risk factors are being in bed, being non-ambulatory, being overweight, history of previous blood clots, generally an unhealthy lifestyle. There's a few things that lead to an increased risk of this. But from the moment you're in bed for a protracted period of time, you then have to say, listen, I am aware what's going to happen here. In fact, I believe it's actually standard practice in Trinidad and Tobago to give you the necessary medication and treatment when you're there. But again, I haven't seen medical records. I don't know whether they've actually did what they ought to have done. Because as I said, you can still develop a deep vein thrombosis even if all the proper things are followed. Right? At that point, you really need to look into what was done and what wasn't done.
Joseph Sookoo is the attorney with us. It is Brunch. You having it with us. It's 20 minutes after 10 o'clock. I am Rennie Bishop. My co-host is Sharmain Baboolal. Sharmain?
We've been looking at more recent cases. Well, the cases that are recent are more recent. Cases that are recent are more recent. I'm sorry, Mr. Bishop. I just got thrown off there by my headphones.
Feedback does that to you sometimes. Apologize.
Throws you off. Yeah. Can we say, and I'm putting you in a tricky situation because you're an attorney and I'm asking you to make a sort of assessment of a judge. Are they judges, do they fully understand the medical ramifications, or rather I should ask you, is the court set up in such a way that judges can be assisted in understanding the ramifications of how do I have it here, the medical ramifications of a case before them, right? I said, although you said, but there are people who are retained within the system, as well as is there a precedent set in the case that we have as a landmark case in 2008 when Samde Harilal, whose baby was stillborn in April 2002 in the midst of an impasse where doctors refused to work after 4 p.m. at the San Fernando General Hospital, and she was left unattended for several hours. She was awarded $300,000 in damages. Yeah? But how do we assess? How do we assess? And is there a precedent that we use? Do we use the British? Do we use the American system? Are we that developed at all?
Okay. That's actually the nub of where medical negligence gets difficult. As I said earlier on, you have experts coming to advise, not necessarily parties, but actually all that's for the court. The judge, like an attorney, like yourselves, we don't really know much about medicine in that regard. We need these doctors coming to court to tell us what's really going on. Now, interestingly enough, you pointed out the ability of the judge. There are two cases you really look at coming from the English jurisdiction that apply in this regard. You have the Bolam test. The Bolam test essentially deals with the issue of causation and liability. You have your experts directly speaking about that. But there's another case called Belitho, which deals with if the answers themselves given by the experts don't actually meet a certain logical basis, the judge will then step in and say, listen, you make no sense, I'm going to rule against you. So that's really the only sort of ability in terms of being outside of the expertise being proffered to the court by the parties, where the judge can really deal with the question of negligence occurring on a medical and factual basis. Coming back to damages now, right? We really work by a rather backward system, I have to say. In 2012, there was a recent judgment by the Privy Council that suggested we ought to work by certain statistical analysis, actually by actuarial figures, right? In England, they have that, right? You have the actuarial tables, which suggest that over a 60-year period in England, for example, you might get a multiplier. I'll explain that later on. But you might have a certain calculation available to you based on your yearly earnings or your proposed yearly earnings multiplied by inflation and all these other curious little things. In Trinidad and Tobago, however, we work on a previous precedent scenario. So we look at previous cases and say, listen, if in 1986 someone was awarded $100,000 for a similar scenario, we can then work based on basic inflation and all that and simply approximate that figure for the current situation.
Precedence is your starting level.
Yes. In fact, it's the only level we have right now.
General Medical Council is something that they have in the UK. Where do we stand on that? And because a general medical counsel would, I believe, assist in the area you're talking about. A judge who does not know, you get folks from this counsel who are experts with no dog in the fight, as it were, to come in and give the evidence. And that should, if you have such a thing, I believe you would ease the cost to the litigant. If you have a general a counsel like that to come in. I mean, do we have that? Are we close to that?
We don't have it. We're nowhere close to that.
Is it desirous?
Well, I'm not certain. That's the honest truth. There's actually a paper that came out in 2012 looking at these sort of things. Actually, in 1996, when England changed their entire legal system, there was a paper done by someone called Lord Wolfe. A lot of lawyers will be familiar with that name, who suggested that one of the major areas that needed to be fixed was in clinical negligence. And one of the areas he focused on is the fact that there really isn't any sort of, let's call it, pre-litigation responsibility that would have helped any manner that you suggest. So in Trinidad and Tobago, we have at best the medical board where you can report negligence and they will investigate and so forth. And in a circumstance like that, where if the medical board does find a doctor being negligent in the criminal or even the legal sense, you can take that ruling, I would suspect, most likely, and put that in the court and say, listen, by a body of his peer has been found negligent, I want my compensation. But besides that very limited opportunity, there's nothing like what you speak of.
Sharmain was so specific earlier, and if you did answer it, you will forgive me because I may have missed it. When she asked the question how difficult it is for a poor man, because depending on what you laid out here, it is very expensive to go ahead into suing, which means you have to go into the situation where the attorney agrees to take it for X amount of percentage after the settlement, which means you got to find yourself a very, very well-endowed, financially, attorney to take your case if, in fact, you're going to get someone who can put out the money necessary to get these medical experts. Is that the case?
The fact is, it's exceptionally expensive. It's so sad. Poor people really can't access medical negligence litigation. As you suggested, you seem to be familiar with the practice of a lot of attorneys where they take a percentage afterwards. That is not legal.
It is not legal?
No, it is not.
But rampant in Trinidad, isn't it?
It is, because
oh my goodness.
In these circumstances, it's very rare that you can deal with these matters in such a thing. Now, I will say, however, that perhaps the quotation, or to say they take a percentage afterwards, might be grossly misunderstood by the client.
Give me the legal name for it. I'm sure there's some way it's couched in legalese that sounds pleasant, palatable.
Well, the truth is, it's what you speak of, contingency fees.
Contingency fees, yes.
Right. We don't allow that in our Legal Profession Act. But that being said, you need to be very careful in appreciating how it works. The way the court system works in terms of awarding costs after the fact, it is pretty much a percentage of what the value of the case is. So very often lawyers work on costs, which a lot of people understand to be percentages.
Okay, we take it to the medical board because we've had so many cases, not necessarily cases of clear-cut cases of negligence, but if someone is paid a sum of money because, for example, well, in most cases, that been the public health system, how can is the medical board, doctors again, is the medical board effective in dealing with errant doctors, or is the profession helped by the medical board?
Well, that's a rather tricky question.
I'm sorry if I end up at the hands of a doctor one day. I'm really sorry.
Yeah, that's sort of why I'm afraid to answer that one.
Just make sure you have a rich attorney.
The truth is, in my experience, there is some remedy there, but not necessarily enough to satisfy a patient. The truth is, the medical board really deals with disciplinary issues. It's sort of like how the Legal Profession Act works and the disciplinary committee for lawyers. You can bring a lawyer before the committee, and the committee may find, listen, you're liable in some way. But that's really punishment rather than compensation.
Yes. Yes, I also have a problem with that. It's almost like it's almost like the political system in the context that you should put some things in place to prevent a problem, but you worry about when I get in power and I have to use these same laws against me. How about if we sat on that for a little bit? And that's unfortunate. Hence the reason I made the point about having an independent body that is paid to monitor the performance and to give testimony when you have cases and stuff like that. I want to go back a bit into how difficult it is making a claim for a person. You've been round, you've been round. You don't have the money because we already established how difficult it is. But the benchmark for proving negligence, you identified some of them, however, but if you don't have the money to pursue it, an ombudsman is my question. Is he the sort of person to pick up your case? Or is Attorney Joseph Sookoo the person to pick up my case without the amount of money?
No, I will say that I have taken up cases for nothing, merely because I know the clients have nothing, just to try to get some sort of remedy for them. But the truth is, an ombudsman can't help you.
Cannot help you.
They cannot. Right? The honest truth is, and I speak from my own experiences here, if, let's say, the lawyers for the hospitals are aware that your client is unable to meet the necessary financial obligations to pay for these doctors to give evidence against them, I've come across a situation where these attorneys have told me, listen, if you can't prove your case, I'm not speaking to you.
You are an attorney, Legal Aid Society. That sort of model, is that something that is available?
I have been approached by Legal Aid once or twice relevant to representing persons in these areas. But the answer always comes back to the same thing, the cost. Legal aid needs to be able to recover some of the costs. It's a very limited fund. And the fact is, you need to spend, realistically, for the more complex cases, well into the region of hundreds of thousands of dollars.
I was quite deliberate when I opened that door because it does raise the question about the allocation of money in the next budget. I would like to see more money put out for legal aid because we are identifying here a no-win situation for poor people. And I'm saying, if you really want to help me with the baby, I'm sorry, if you really want to help me with the problem, then I want to see some money put into the legal aid. It is something that has to be paid attention to. Otherwise, there is no redress. And if there is no redress, it's a gross injustice.
Well, I actually disagree with you there. I think you're looking at it from wrong perspective. In my honest opinion, because I have so many colleagues actually in the medical profession, it's part of why I got into this area of law as well. I have seen that the public health service is grossly underfunded and the doctors therein are grossly overworked. Medical negligence is really nothing more than human error.
Right.
And human error is something you really can't move away from unless you have the necessary manpower to reduce the risk of that. So, for example, there are cases where, I won't quote them, but there are cases where doctors are on, actually I can, Samde Harilal. In that matter, the doctor who actually came out was on maternity leave, 8 months pregnant. She came out to do the case, right? And having done that, she came out, she met an adverse situation, did her best, and still became, not necessarily her, but the hospital was liable. Why? Because what had happened really was that the patient had been sitting down there for hours upon hours. And whilst during this time, there was the opportunity to assess the patient. She had certain risk factors that made the C-section, or rather giving birth via the method they used, to be risky. And they did not really look at that. By the time the doctor came in to look at the situation, things had already progressed to a stage where it's either do or don't. So when she did, she should not have. And the ultimate outcome of that case was to say, listen, if you're not able to treat the person, send them elsewhere.
Yes.
Right.
So I think your point you made, and I concur with it, is the case of the chicken and the egg. Which comes first? The first thing we need to do is to get our medical professions equipment and the assistance they need. Get the training up, get the tools, the equipment in place, and then worry about legal aid. Is that what you're saying?
You're correct. You're actually spot on, because the vein thrombosis, for example, I am vaguely familiar with this because I've only heard it through the grapevine or so. But for deviant thrombosis, you normally have it diagnosed by using a Doppler ultrasound. And this machine was only available in Port of Spain, I understand, about 7 or 8 years ago, and often breaks down. You know, I mean, realistically, what else are you supposed to do there? When the machines you need to do your job aren't available, you run the risk. And situations like that, you have doctors working 48 and 72 hours in a row, and that is madness.
Another area that we will look at some point. Attorney Joseph Sookoo is our guest this morning.
I just want to add a bit, clarify something here, and it was brought to my attention by Deborah John, features editor at the Trinidad Express. Thanks very much, Ms. John. She says an independent team was brought in for the Cuttles and it was headed by a British female gynecologist. Her name is Dr. Melanie Davis of the UK, and she was in charge of it. So that's the independent probe for which millions of dollars was paid for a probe, and the Cuttles are still out in the cold.
Ironically, if you look at the Sandy Harilal matter, you would see that even before the court of law, the sort of money you spend on the probe, it wouldn't meet the damages you'll get according to our current regime, right? If I recall correctly, the actual damages wasn't 300. I think it was 140 reduced to 120. Realistically, $100,000 being for the damage to the mother for not having a successful childbirth, and $20,000 for the death of the child. Now,
you may have only been you're back in Trinidad and working for the past 4 years and getting into medical negligence cases. Where do you see what are the systems that we can set up within the area of law to make it easier? Well, outside of legal aid, which is also a complex issue, and to make it easier for people, because, for example, someone seeking redress to the courts in any event, you start a case. In the case of Samdi Harilal, in 2002 she lost a baby and she did not get any redress in 2008, and that's how it will go, which will add to the costs of litigation for the poor person, even a person who's considered rich in Trinidad. I'm sure court matters would debilitate their funds.
Well, Samdi Harilal is actually from an older regime. In Trinidad and Tobago, the law changed in 2006 to speed up the court process. So a medical
negligence issues, or generally?
Generally, across the board. Medical negligence is nothing more than a subset of negligence itself. It's if one wants to really simplify it, it's pretty much a complex version of a car accident. You know, who's wrong, who's negligent, and you go forward from there. In my experience, I would say that a medical negligence case can be resolved as early as within a year. But if you're going to go all the way down, it could take you 3-4 years.
If I could beg you then to lay out 1, 2, 3, 4, the top 4 things one who believe they've been wronged must go look into, prepare themselves with before they go into taking action against a doctor or institution, what would they be?
Well, the main thing you need to do is have your medical expertise in place. You know, you can't simply say, listen, I believe I've been wronged, let me go file a lawsuit. Right, you need to have a doctor in place. You need to have your specialists in place. Say, listen, I've looked at the papers, and of course, that's a whole other situation altogether. Right, there are cases where hospital records have gone missing. You know, they can't be found. They've been destroyed. You know, but that's bad enough already. But upon
also called fraud. But go ahead.
Well, it's called something. But you're looking at a situation where you realistically need to have someone assessing your case from a factual medical point of view before you even make that expensive litigious step to enter the courthouse. So the first thing you need to do, get your papers together. The second thing you need to do, get your doctor to advise you on it, and not just a doctor. You need someone in that area. So, for example, in a situation with a deep vein thrombosis suffered during childbirth, you need about 2 or 3 doctors to advise you on that. The first, you need a vascular surgeon. A vascular surgeon would tell you, listen, a deep vein thrombosis occurs in certain situations. So the vascular surgeon deals with blood and deals with veins. So it occurs in this situation. What are the sources of treatment? These sort of things. You may need as well, let's say, an obstetrician or gynecologist to say, listen, if you're going through this particular procedure, you're going to suffer a certain period of bed rest and so forth and so forth. And when in that circumstance, you have to look at these things. And then you may need, given the sort of injury you suffer, you may need to look at, say, listen, if I'm going to suffer a permanent injury, how does this affect my lifestyle? And you need a doctor to come and say, listen, you are suffering from a certain disability, and now you need to deal with it in a particular way. You need these surgeries, you need X, you need Y. So you're looking for, let's say, the more complex cases. You're looking realistically at between 3 to 4 doctors.
Which takes it exactly. He's shaking it. Which takes it basically. We're hoping that we get solutions from you. Yeah, it takes it out of the hands of the average person and the above average income earner in
Proper
Trinidad.
smoke your pipe if you get injured. I mean, at the end of the day, and you don't have money. That's essentially what we're saying. And which begs the question, is there anybody you know of that is set up where one aggrieved can go to? And if not, do you join in what I think we should all advocate for, which is that such a body be set up?
The difficulty with such a body existing is legitimately time frame. The truth remains that in England they suggested the exact same thing, but they didn't really pull it off. Because what occurs in a situation like that is that the first thing you do, you get your papers. You must have a certain time frame available to you to go to this body. You go to that body. The body takes its time to come up with a solution. During this time, papers go missing, doctors aren't cooperating, a lot of the different things like that. And then when you hit that 4-year limitation period, you're out of any real remedy again. The ultimate problem is how best to reduce the cost of coming to court. Now, don't get me wrong. There are, in my view, certain rules within the current court process that allow you to reduce your liability in that regard. I am familiar, and I have argued that there are rules that suggest that the hospital can pay, or the other body, the one who has more money, can pay for these experts for both parties to rely upon it. So in a circumstance like that, we come before the court, we have a certain belief that we have a case, we need the experts in place, and you make an application, you ask the court to say, listen, I want an expert in this. We don't have the money, but the other side does. The hospital does. Let the hospital bring the experts and let us rely upon what they say. Of course, in a circumstance like that.
No, that's dealing with a bad deck.
Not necessarily. I mean,
it's stacked against you. You ask them to bring the expert, and you're hoping to goodness sake that the expert does not have a bias. That's basically.
Well, yes, but of course, in a circumstance like that, there are certain things in place to try to avoid that. Okay. So you may recommend foreign experts or so forth. I mean, the law suggests that the expert must not be biased, but that's pretty much a problem.
You really must forgive me, because when Sharmain spoke to me about this, I came in with this hope and this little optimism that there was a couple of things in place that folks can get redressed. But the reality is, the dose of reality I get from you is, you're cooked. If you don't have the money, you're cooked.
Yeah, it's quite difficult. If you have the more bigger cases in a circumstance, so let's not use baby Cottle because the child died, unfortunately.
Yes.
But surprisingly enough, what would make a case against the doctors, I guess, workable is if the baby had survived and had survived with a horrendous injury. Because when you look at that, the amount of damages and all that occur, it makes it possible for people to take the risk, attorneys, experts, and so forth, to take the risk that you go to court, you will get a substantial payment, in which case you can pay everyone after the fact. But save in those circumstances, it's the same problem that this exists in England, the same problem that exists in the United States. The smaller cases, you're going to find yourself in a lot of problems trying to find people to give you that work you need to bring it to court successfully.
And as well as because the regional health authorities, they are the one who are liable, right? The doctors don't face any personal consequences for if there is anything that goes wrong, as in the case of Crystal Boodoo Ramsomere, 29, a mother of 3 who died at the San Fernando General Hospital in 2011 after undergoing a C-section procedure. On November 2nd, 2012, the Southwest Regional Health Authority, through its attorneys, accepted institutional liability for Ramsomere's death. So in such a case, it's a little opening there. You come out openly, go to the press, highlight your issues. This is a matter. There's some good and compassionate lawyer who's going to say, yes, that's it. And at the end of the day, out of court, the regional health authorities will have no choice but to settle. So there's a little bit of light in the tunnel, Mr. Bishop.
I don't know. It still looks dark to me, because I'm waiting for somebody to step in. When I pay taxes as a taxpayer, I can make demands on my government, I believe, to get a body in place that understands that I may not be able to reach that financial bar, and have some organization out there, organizations paid by the government, by my money, to walk in and assist those who find themselves in the situation. You've been very candid, and for that I thank you, but it did leave me a little depressed.
Unfortunately, that's what there is. But I can give you suggestions. So.
Yes, you can.
Yes, indeed. In England, for example, they put aside 1/3 of their health budget to deal with complaints.
Thank you.
But that's really the best case scenario. I don't know if we have the finances.
And that is of course we do. For God's sake, money is spent all the time everywhere. Even people who are not spending money are banking money. Don't get me started here.
So besides,
it's about 43 billion pounds they put aside for that.
Yeah, but look at their population. I mean, I'm just saying it is costly. Everything is costly. At the end of the day, if the government cannot equalize the field for its citizenry, what's the purpose of being in governance?
Not commenting on that one.
Just a question.
Are there other issues, other proposals that you want to make for us to solve it? Because that's just one. You said you had some solutions.
No, well, that's one of the ways. If you put aside a certain amount of money to deal with what's going to happen, you can perhaps speed up the process and make it more open and viable. But in the circumstance you spoke there about ransomware, that's quite rare. So you really need, I think, from the very beginning, if negligence is going to be alleged, or if negligence is a possibility, you need to have open and honest discourse, and someone needs to pay for that.
Open and honest is what you've been with us, and for that we thank you very much for taking the time to be with us. Attorney Joseph Sookoo, thank you for coming in this morning. You did not have brunch when you come in because it was not on the table, but I am informed it is right there waiting for you right now. Do go partake and enjoy.
Thank you very much. Glad to be here.